Yes, Judge. I attached the exhibit of the orange sticker that was placed on my car.
When was that
Um,
sticker discovered?
I I believe it was May 21st.
Is that when you
Um,
found out or when it was placed?
yeah, that's when I went out and found it on my car. And I would like to just mention a couple things about the sticker, if that's okay, Judge.
Before this hearing even begins, here's what makes this case so fascinating. A simple parking dispute is about to turn into a courtroom battle over one critical question. Was this vehicle parked on public property or private property? That single detail could determine whether the towing company and the property association acted within the law, or whether
Mr. Zeiker, what day was your car towed?
The car was towed on June 6, 2026.
Mr. Manning, is there any dispute here?
Your Honor, in the CCNRs, it does provide, it's section 4.27 of the CCNRs of Boulding Creek. It does provide that the private streets, they are private streets, they're not public. And it also does, we did have HOA signs, and the car was parked there for quite a long time, and we did post a parking sign or to move the car sign on the window of the car. And I think it was parked there for about a month. And so we do dispute that it was a public street and that it was improperly towed. However, we understand that this is kind of a de minimis amount of money. And rather than moving forward with further litigation than this, we'd like to entertain these settlements, but that's where we are.
Okay. All right, Mr. Zeiker, where was your car parked on June 6th?
Judge, so I did submit a number of different exhibits. I'd just like to see if the court is, if that's visible to the court. So as I explain the exhibits.
Just tell me where you were parked. Were you in a street, in a
Okay,
parking lot,
yeah.
garage?
I was on the public roadway
You were
on
parked
the
on
east
street?
side. Yeah,
Okay.
I was on the public roadway on the east side of South 2nd Street, right? Right in front of 909 and 911 South 2nd Street. So 900 South 2nd Street, the condominium community is on the west side of South 2nd Street. I was on the east side of South 2nd Street. And those are completely different properties. The tow sheet indicates that they towed me from 900 South 2nd Street Bowlingport condos. I was not on their parking facility. I was not on any of their private property. And I was not blocking any driveways or drive aisles. And I have the exhibits to show. I did take photographs at the time I parked because I would just returned from the H-E-B grocery store, which I attached an exhibit for my grocery receipt with the date and timestamp.
Zeiker,
Okay.
not me. Let me show some photos.
Mr. Zeiker, I'm looking.
When
Can
did
you
you
see my
discover your
screen?
car
I'm
was
sharing a
towed,
photo.
Mr. Zeiker?
On June 6th.
And how did you find that out?
I have a air tag in my car, and I sporadically check it throughout the day, and I saw it moving southbound, and then I called the Austin PD, and they informed me that it was taken to a tow yard, to the Reliant Towing.
Prior to your car being towed on June 6th, did you receive any warnings of any type related to you parking your vehicle?
Yes, Judge. I attached the exhibit of the orange sticker that was placed on my car.
When was that sticker discovered?
I believe it was May 21st.
Is that when you found out or when it was placed?
Yeah, that's when I went out and found it on my car. And I would like to just mention a couple things about the sticker, if that's okay, Judge.
Mr. Zeiker, before we get into that, after you found your car with the orange sticker, did you move your car?
Between May 21st, yeah, because I went to the grocery store on June 2nd.
Cool.
So
As you
multiple
testified
times
earlier,
before
in
that.
the photo you showed me, you drove your car and parked it on June 2nd in that spot and then didn't move it until it was towed.
Yes,
So anything that came from before that, kind of irrelevant because you'd already moved the car.
correct. Yeah.
Cool, then we can move along.
Correct.
I'm not worried about the orange sticker. Between June 2nd and June 6th, had you been given any notice whatsoever that your car was going to be towed?
Between June 2nd and June
Yeah.
6th.
The date of the photo you showed me, you showed up, you parked your car. Did you receive any notice after you parked your car before you discovered the air tag moving that your car was in danger of being towed?
No, Judge.
Have you gone back and inspected the location where you'd parked?
Yes, Judge, after being towed, I returned to South Second Street and I took additional photographs of the street, a wider view of the street, as well as the entrance of 900 South Second Street, which is the Bowling Court condominiums. And I supplied exhibits of
What
that.
day were those photos taken?
I'm sorry, Judge, what was that?
What day did you take that second set of photos?
On June 6th.
June 6th.
The same day that it was
same day
towed,
you
I
were
just
towed?
returned. Yeah, I returned right after picking up my car from the tow yard.
All right, let's take a look.
Yeah.
Photos after tow. I see those are labeled as such. I'm going to share my screen now.
Entrance right there. Yeah, that.
Mr. Zeiger,
Okay.
what did it cost you to get your car back?
I paid cash for the tow, and it was $321.45 at Reliant Towing.
All right. Mr. Manning, what information would you like to show?
Your Honor, as I stated earlier, Reliant Towing did place a sticker on Mr. Zeiger's car on May 22nd. The next day, he moved it. And the association does maintain that the place where Mr. Zeiger parked.
Do you have any proof? I appreciate what you're saying. The association believes it's their private property. Do you have proof of that? Can you show me a deed that says this land is included on their land? Because it looks like a public street to me, and there's absolutely no signage whatsoever around there.
Your Honor, I do not.
Okay. Judgment for plaintiff, cost of court, and $321 for your tow fee. Y'all have a good day.
Thank you.
Thank y'all very much. Mr. Zeiger, be
Thank you,
careful out
Judge.
there. Mr. Manning, I understand it's all development. Life's good. Y'all have a nice afternoon.
Thank you.
Thank y'all
Thank
very
you,
much.
Judge.
This is the moment where the entire case shifts. Up until now, both sides have presented their versions of events, but courtroom cases aren't won by confidence. They're won by evidence. Notice how the judge immediately asks for proof that the disputed roadway actually belongs to the association. That's a legally significant question because if the association claims private ownership, it's generally their responsibility to support that claim with documentation, not just statements or assumptions. Without deeds, plats, or other property records, the argument becomes much harder to sustain. What do you think? Should an HOA or property manager be allowed to authorize towing without being able to prove the land is actually private? Let us know your thoughts in the comments before you hear the judge's final decision.
Good morning, sir. You'll need to press *6 on your phone.
Yeah, sorry, it took me a second, Your Honor.
You're
Yes, I'm Mark Schrader with Reliant Towing.
All right, what case are you here for, sir?
Matt Zucker.
Oh, we just finished that case. Mr. Schroeder, I appreciate it. We literally just finished it. We began at 10:30.
10:30. It said 11.
10:30. Yeah. We literally just started. Mr. Schroeder, you're fine. Mr. Manning appeared on behalf of the complex.
Yeah, I'm looking at I'm looking at my hearing notice right now, and it said 6:24 at 11 a.m. If I knew how to share my screen, I could do that.
Sir.
But
You are absolutely correct. Stephanie?
I am looking at that, Judge.
well, let me ask you this: did Bowling Court win?
No. It was a public street. There was no towing signs. We didn't have any proof. Mr. Manning pretty much conceded that they didn't have any proof it was their land, that it was... I said, if it's a public street, if it's a private property, show me a deed. And he goes, yeah, we don't have that. I said, cool. Judgment for plaintiff. Pretty easy. There's no signage.
All we had was an email from them stating that it's their property and
Absolutely. I totally believe that. And there may be a real dispute with the owner about what that land is theirs or not, but without like the deed that shows it's part of their land, it looks like a public road and there's no signage. But what y'all did, you're following what y'all were told to do, right? What I'd say is there might be a real confusion with the owner about whether that street is private or public. Part of the way it looks though, it looks public and there's no signage whatsoever around it.
That's above my pay grade.
Yeah, you're great, Mr. Schroeder, and I appreciate you drawing the attention to it, though. I want to make certain that we're clear about that because we set our docket at 10:30, and we have 3 cases at different times. We believed yours case was at 10:30, and that is the mistake of the court, so I apologize for that.
Well, it was found against Bolden Court, not Reliant Towing?
It is, the
Since-
case was filed against WRMC or Bolden Court. It was not against Reliant.
Well, this was on them, so that's good enough for me. Okay.
Thank you very much, Mr. Schroeder. Have a good morning.
Thank you, Your Honor.
This case ultimately came down to one fundamental legal principle. Claims require proof. The plaintiff presented photographs, a clear timeline, and documentation showing where the vehicle had been parked, while the defense later appearance by the towing representative also highlighted an unfortunate scheduling mix-up, but the judge clarified that the ruling was based entirely on the evidence presented in court, not on anyone arriving late. Cases like this are a reminder that documentation often makes the difference when property rights and towing disputes are involved. If you found this courtroom breakdown interesting, make sure to hit the like button, share your thoughts in the comments, and don't forget to subscribe for more real courtroom cases, legal analysis, and jaw-dropping courtroom breakdowns.